The attorney-client privilege is a legal principle that protects communications from being disclosed without the client's consent. It allows individuals to candidly discuss their legal matters with their tax attorneys without fear of their discussions being used against them. In the context of federal tax matters, this privilege can be particularly important because individuals may need to discuss sensitive financial information in order to properly address their tax issues. One key aspect of the attorney-client privilege in federal tax matters is that it only applies to communications made for the purpose of receiving legal advice. This means that if an individual is discussing their tax situation with their attorney in order to get advice on how to handle the matter, those communications are protected by the privilege. If the individual is discussing their tax situation with their attorney for some other purpose, those communications may not be protected. In addition to communications, the attorney-client privilege also protects certain documents that are created for the purpose of seeking or receiving legal advice. This includes documents such as legal opinions, briefs, and other written materials that are prepared by an attorney for the purpose of providing legal advice to their client. The attorney-client privilege is to be asserted by the attorney on behalf of his client, or it is waived. One important exception to the attorney-client privilege in federal tax matters is the crime-fraud exception. This exception allows for the disclosure of otherwise privileged attorney-client communications if made in furtherance of a criminal or fraudulent act. This includes civil fraud that does not rise to the level of criminal fraud. To invoke this exception, the moving party must show probable cause that the individual communicated with their attorney with the intention of committing a crime or fraud. The party seeking the exception must first demonstrate that there is probable cause to believe a crime or fraud has been attempted or committed. Party then needs to show that the communications were made with the intent to further the crime or fraud. This exception applies even if the attorney was unaware of the criminal or fraudulent nature of the communication. The crime does not need to have been completed for the exception to apply. Facially legitimate conduct may be considered as being in furtherance of fraud under certain circumstances.